Okay, the topic for Module 6 is Guidelines for Paralegals Acting Ethically. The first topic we will address is whether a paralegal can draft organizational documents. We're going to start out by looking at Ethics Board Opinion 07-1. The facts are that a paralegal has asked whether or not volunteering to draft bylaws or being asked to draft bylaws for a neighborhood association would be an ethical violation. The Ethics Board held that drafting bylaws or any other documents for an organization or volunteer association is not allowable if the paralegal is acting on his or her own and not under the supervision of an attorney. This would be a violation of the NFPA's Model Disciplinary Rules and Ethical Considerations 1-3 Part B and 1 Part 1-8. So members of an organization actually do not require an attorney to draft their bylaws, or a corporation drafting articles of organization, or a limited liability company drafting operating documents. An attorney is not actually required to draft those organizational documents for companies and associations. However, the problem arises where someone who is not a member of the organization does undertake to draft them, because that could be considered the unauthorized practice of law. So as long as if the paralegal had been a member of the neighborhood association, a member of an association can participate in drafting bylaws for the organization. But a paralegal who is not a member of an organization cannot assist in the drafting of a legal document for that organization. Drafting bylaws would be equivalent to drafting contracts. If the organization chooses to do that for themselves, fine, but a paralegal cannot act in that role without the supervision of an attorney. Any questions? Let's talk about real estate closings, whether or not a paralegal can assist the client at a real estate closing. Well, the answer is going to depend on the jurisdiction or the state in which you're practicing as a paralegal. Connecticut permits paralegals to attend real estate closings even though no supervising lawyer is present, if the paralegal does not render an opinion about the execution of documents, changes and adjustments, or price or other matters involving documents or funds. Florida permits a paralegal to handle a real estate closing at which no supervising lawyer is present, provided the paralegal does not give legal advice or make decisions that should actually be made by a lawyer. Georgia, the Supreme Court of Georgia, and formal advisory opinion 86-5 has held the closing of real estate transactions constitutes the practice of law. It is ethically improper for a lawyer to permit a paralegal to close a real estate sales transaction in Georgia. So it's going to depend on the jurisdiction in which you're practicing. So you definitely need to look up the laws in your state. Some states permit paralegals to do a whole lot more than others. Let's talk about disciplinary actions against attorneys for violations of the ethical rules. Serious consequences can result from a lawyer's failure to properly designate tasks or to supervise the paralegal. The Supreme Court of Virginia upheld a malpractice verdict against an attorney that was based on the negligent actions of a paralegal in performing tasks that were properly delegated. So the doctrine respondeat superior, which is Latin for the superior response, the lawyer will respond and be responsible for any negligent actions that he or she has delegated to the paralegal to perform. Disbarment and the suspension from practice of law may result from a lawyer's failure to properly supervise the work performed by paralegals. An attorney has received a 90-day suspension for abdicating responsibility for a case to a paralegal without supervising or reviewing the paralegal's work. And you should keep that in mind when you think about the Module 6 assignment and writing that memo to the Ethics Committee. Lawyers have also been subject to monetary sanctions for failing to properly utilize and supervise paralegals. A law firm violated Rule 3-110, subsection A of the California Rules of Professional Conduct by permitting bankruptcy paralegals to undertake interviews, fill out forms, and complete schedules. Those are attachment to bankruptcy filings without the attorney's supervision. So filling out bankruptcy forms, interviewing clients, completing documents that have to be filed with the court in a bankruptcy proceeding, the attorney needs to supervise the paralegal in those matters. Any questions? So as you prepare to take the Module 6 quiz, you want to do a review of the ethics and ethical regulations that we've learned this term. The ABA model rules of professional conduct set the ethical standards for lawyers. The ethical standards for paralegals are located in the NALA ethical canons and the NFPA ethical considerations. As a refresher, you should navigate through the slides that are shared in the Module 6 lesson content. So let's go into the online classroom and take a look at that Module 6 lesson content. Okay, so I'm going into the legal ethics course. Clicking on Module 6, going into the lesson content. And here we have a summary of ethics and ethical regulations. So you want to, as you prepare for the Module 6 quiz, make sure you review these slides. On the unauthorized practice of law, which we discussed in Module 1, paralegals must be careful to avoid the unauthorized practice of law by avoiding tasks that only an attorney may perform, such as providing legal advice, disclosing his or her status as a paralegal at the outset of a professional relationship with a client. You can review NALA Code of Ethics and Professional Responsibilities, Canons 1, 2, 3, and 5. Confidentiality, we talked about the duty of confidentiality in Module 2. Lawyers and paralegals have a duty to maintain the confidentiality of their clients and their cases. Candor to the tribunal and impropriety, legal professionals have a duty of loyalty to their clients. Concurrent with that duty is a prohibition against deceiving a court or a tribunal. These same rules apply to paralegals, as paralegals are prohibited from engaging in conduct or taking action which would assist or involve the attorney in a violation of professional ethics or give the appearance of professional impropriety. Again, paralegals are prohibited from engaging in conduct or taking action which would assist or involve the attorney in a violation of professional ethics or give the appearance of professional impropriety. Conflicts of interest. Lawyers must be careful to avoid conflicts of interest when dealing with their clients. A paralegal is required to disclose to his or her employer or prospective employer any pre-existing client or personal relationship that may conflict with the interests of the employer or prospective employer or their client. Now, for attorneys, if there's a conflict of interest perceived, such as representing the husband and wife in a divorce, that could be a conflict of interest because they could have adverse interests in terms of child support, they could have a child custody battle. There could be issues of fault in a divorce where the husband and wife's interests are adverse, ordinarily they would get separate counsel. They would not be represented by the same attorney. However, clients can waive a conflict of interest by giving their written and informed consent. And when a paralegal comes to work for a new employer, the paralegal is required to disclose any pre-existing client or personal relationship that may conflict with the interests of the prospective employer or their clients. Competency. A paralegal is to strive to maintain a high degree of competency. Under the NFPA Model Code Ethical Consideration 1.1, a paralegal should obtain competency through training, work experience, and education, and always be prompt and efficient. Attorneys have been held responsible for legal malpractice and delaying filings with the court on behalf of the client. Duty to report. Paralegals have a duty to report the conduct of legal professionals that clearly demonstrate fraud, deceit, dishonesty, or misrepresentation. So you would need to report that to the appropriate ethical tribunal in your jurisdiction. Okay. Let's go back to our live classroom and take a look again at our presentation. So your Module 6 quiz is going to be cumulative of the ethical rules we've talked about all term long. So I took the quiz and I got an A, and I'm going to give you a review of some of the concepts that I think would be important to know for the quiz. How's that? So you should review the rules on the unauthorized practice of law. Know what it is. Remember, paralegals cannot give the client legal advice or set fees in a case. The attorney-client privilege and the duty of confidentiality also apply to paralegals. Paralegals must be aware of ethical rules and court rules in their state or jurisdiction. An attorney may represent clients with adverse interests if clients give written and informed consent. When a paralegal is hired, a conflict of interest check should be completed. And an ethical wall must be set up if a paralegal has a conflict of interest with a particular case that's being worked on in their law firm. So you have an hour to take the quiz, and if you don't do a good job on it, you can take it again. You have 2 opportunities to try to get the best score possible on the quiz. Just be sure to submit your correct answers by Tuesday at midnight Central Standard Time, because Tuesday is when the course ends. Let's go over your written assignment for Module 6, which is responding to an ethical investigation. This week's written assignment builds on the Module 5 written assignment, so you have the same facts. Your supervising attorney is taking a trip to Las Vegas and will be missing a hearing with his clients, the husband and wife, in a divorce case. So last week you wrote a memo to the Ethics Committee reporting your conversation with the attorney. The Ethics Committee has now decided to report the attorney, the paralegal, and the judge to the appropriate authorities. So your assignment is to prepare a report describing the differences between attorney and paralegal code of ethics, explain the investigation process for the governing bodies for attorneys and paralegals in your state, including any further involvement that the law firm might have in the process of investigating this alleged misconduct, and discuss the potential outcome of the investigations. What sanctions might be imposed on the attorney, the paralegal, or the judge? So, again, your assignment should be formatted as a memorandum to the firm's ethics committee. Your memorandum should be 1 or 2 pages in length. Proper formatting Spelling and grammar, you should use at least 3 primary legal sources in your memorandum, including case law, as well as citations to the ethical rules for paralegals and attorneys. Your memo should contain the following sections: a heading or caption, facts, the issues presented, the answer to the issue, the reasoning or discussion, conclusion. And again, you need to cite to the pertinent and relevant ethical rules of conduct. If you need assistance, be sure to click on the resources that have been given. How to create a legal memo. You'll be creating this in Microsoft Word using Lexis Advanced or FastCase to do your research. And again, this assignment is due Tuesday, August 11th. Let's go back again into the online classroom so I can share with you the grading rubric for your Module 6 written assignment. Okay, so to review the grading rubric for any assignment, you simply go to the module for that assignment. And we're looking at the Module 6 written assignments. Go under Assignments. There's your assignment. Click on the title of the assignment. And then notice it says Points Possible Review Rubric, so you want to click on that. I know I've shown you this before, but I want to show it to you again. There is your grading rubric in detail. If you want to see where your points are coming from for any assignment, this is how you would do it. You would take a look at your grading rubric and just make sure that the memo that you create addresses and meets all the criteria. You should be comparing and contrasting the ethical rules for attorneys versus paralegals, talking about the enforcement process, an advanced analysis of the investigation of the ethical misconduct. What potential outcome? Talk about the outcomes of the investigation. Is there a criminal sanction? Will someone be charged with the unauthorized practice of law? Will the attorney be disciplined? Will a monetary fine be imposed? Again, your mechanics, there should be no errors in spelling, grammar, mechanics, including citations. You want to follow the Blue Book format. Again, as paralegals, the documents that you prepare will be reviewed by attorneys and judges, and they know how to spell. So you want to make sure that you run spell check and use Grammarly so that you have proper spelling and grammar and Blue Book citations. References, use at least 3 on-target primary legal sources. It can be pertinent cases, relevant rules of professional conduct. So this is your grading rubric for Module 6, and you know how to access that. Again, by clicking on the title of the assignment and then view rubric. Any questions? Well, that wraps up the Module 6 live session. Again, there is no live session question for Module 6. 2 assignments. Simply submit the correct answers to your Module 6 quiz by Tuesday, August 11th. Submit your memo to the Ethical Committee by Tuesday, August 11th. And remember, no assignments can be accepted for grade after Tuesday, August 11th at midnight Central Standard Time. If you have any questions or concerns, please feel free to reach out. My e-door is always open to you. And thank you again for all of your hard work and dedication on this term. Have a great week.